They had choices. Bad consequences. 23 CR 229 is called the State of Texas versus Cedric Fontenot. That's you?
Yes, sir.
Present with your attorney, Mr. Burbank, and the state's attorney. There's a motion to modify defendant's bond conditions filed April 4th. And
Did you get the memo?
okay, first of all, let's look at something else. This is an indictment that was handed up over 2 years ago. Where are we on this? Where are we on
trial, Judge.
Ready for trial, Judge.
Okay, we're ready for trial?
Yeah.
All right. Okay.
Instead of altering the bond conditions, why don't we just set it for trial
Well,
quickly?
that's what you want. We'll set it for trial. Okay, it's set for trial as soon as we can get to it, okay? Then you've got a motion to modify, he's filed this on April 4th,
Yes, sir.
and it states the defendant was released on bond with conditions he wears a GPS ankle monitor, remaining under home confinement and refrain from operating a motor vehicle, requesting the court to modify that provision that he must remain on GPS ankle monitor. In addition, defendant is requesting that home confinement be lifted as well. Okay, so what bond conditions do y'all want?
It's basically.
If that pretty much wipes it all out,
What we'd like is to be released from home confinement. He's unable to work. He lives with his mom.
okay, wait, I generally allow.
Well, you didn't.
Work. Is there any reason that he can't be allowed to go directly to and from a workplace?
He's in the flea.
Any objection to that?
Yeah.
That's what I normally do. I allow that.
Yes,
As
sir.
long as it's informing the people who are monitoring him, they know where he's going. And he can go to and from to get food and necessity, to and from church, to and from medical care. Those are exceptions in every case. Otherwise, I'll be held responsible for somebody dying of starvation in their house. I don't want that. I know. He can
But he
do a
lives
couple
with-
of days.
So mom
but-
takes care of him. He's in the flea market. He buys and sells flea market, so like Winnie, he doesn't need to go to Houston. He buys and sells for people. He can tell them where he's going prior. They're usually on weekends and days, so he'll have prior notice. And if that's okay, then I will have him notify the GPS people. And tell them that this is where we're going. But he's living at home. He's been at home. Mom's there to supervise.
So you got someone to drive him?
Yeah, his mom. Yeah,
Yeah, he can't operate a motor vehicle.
No, he's not driving.
What's
He's not
state say? Any objection to that? I normally
I know you normally do,
allow
Judge.
to and from the most direct route possible, as long as we get a heads up.
I just
But
want to make
it's not a
sure.
vacation. You're not going on a vacation. You're not
As long as
this is,
we know why he's where he's at, Judge, you always allow that. We do have trial set for September 8th right now.
okay. Well, I will grant the motion for purposes. He's going to wear a GPS monitor.
Yes, sir.
You're going to remain in home confinement. You're going to refrain from operating a motor vehicle. The exceptions to the remain under home confinement is you can be allowed as long as you pre-notify the monitoring official.
Yes, sir.
That you're where you're going for work purposes in the most direct route to and from. You can't drive a car. Somebody else is going to operate it. You can't go to and from food. If you need food, to go to buy food. To and from hospital care if necessary, and to and from church.
Right.
That's it.
Yes, and me.
And to and from legal counseling. Again, all in the most direct route possible. We've had people who are taking wide berths, and we know what's going on, and those lose their privilege.
Yes, we'll do. He's complied with all the rules and regulations.
I know that was up to now. Tomorrow is a new day. I'm worried about making sure that this is followed until we can this case disposition.
May be excused.
Yes. Anything else? Tom, working on the road. He's working on the road.
He does a good job,
Good.
Judge down, Sabine Pass.
Good. How much you making an hour there, buddy?
2750.
2750. That's a fortune to most people. That's over $50,000. Good for you. Don't lose it by, acting foolishly. What are we gonna do today? It's an announcement.
Announcement,
Yeah,
I just asked for a short recess, maybe 2-3 weeks, and,
3 weeks. You got it
there wasn't a bond condition.
on this one? No, it's
It's on my calendar, they might have mixed it up or something.
no, it says announcement and it says I don't see anything. It says defendant on bond. That's all it says, but that's what it says in every case that we're on bond. There's no, yeah, here, you want to look it up?
It's nothing there.
Yeah, ain't nothing on.
It wasn't a modification on us. I thought that he had done something wrong on bond. I did
That's
not.
the negative aspect that you want to take, yeah.
They're going to work at home.
Sorry?
I said, I'm going straight to work at home.
I'm sorry, I can't hear
He
you.
said he
I've been going straight to work at home.
go straight to work.
Good.
Not staying out.
Does he have a GPS device or something?
No,
Yeah, I don't think did I order that? I don't think I even ordered that.
he's been to court before.
Good, that's the least amount
Go back to work.
of harm's way.
Oh, you want the defendant's option?
Yeah, yeah, if there's any, there's not.
He's fine, he's fine. He filed.
They don't go in, they don't,
I'm not. All
all right. In 24 CR 2449, you were JW Marshall, present with your attorney, Mr. Burbank, and the state's attorney. Mr. Burbank is your attorney, correct? Yes, sir. He's filed a bunch of motions on your behalf. And, okay, these things that you're filing, the court doesn't accept that. You have a lawyer. This is what's called hybrid representation, which is disallowed under the law. You've got to either trust your lawyer, you run this by him, then he'll do what needs to be done. But this is not, or not things I'm going to consider because he's the lawyer of record. You have a right to be heard, of course, but you can't have two lawyers unless you pay for them. You and him can't do it at the same time. Yes, he's been assigned. I don't know, did you hire him?
No, I was.
Okay, you appointed, and okay, you want to represent yourself? Anytime you want to do that, let me know, and that would be a bad choice. It's always been a bad decision, but some people are insistent and it never works out well for the defendant. But that's been our experience in this room with 18 and a half years and 600 jury trials. We can figure out what's the right way and what's the wrong way. We've seen it so many times. But this is, when you send this, the court's not going to receive it because you have a lawyer and he's the one responsible for filing the motions and representing you. So you don't want to get into a spot of where, well, if you're going to be doing it, he's gone. See ya. He's a wise man and he's a good lawyer. You got to trust, run it by him. He knows how to do it and what is the best way to represent a defendant. Okay?
Yes.
All right.
Your Honor, if I may, one of
Yes.
the motions that he did file was for a possible bond reduction. I did file an amended motion that I signed on for. The basis, if I may address the
Yes, sir.
court briefly,
Yes,
is that prior to the charge of murder being filed against him, he was out on bond. There are other cases in this file that he was taking care of, and he was on bond. He was compliant with all the rules and regulations, showing up to court, abiding by the rules and conditions. When this new offense came, then they, of course, put a new bond, raised the bond on the murder charge. And he's been in custody since then. He's asking for consideration, possibly reducing the bond down. No, I would.
Okay, this in summary states the bond is presently at $1 million. And you are asking on behalf of the defendant that the bond be reduced to an amount that the court determines is reasonable. I know what the background is on why this was done this way, but does the state have anything to add here?
Yes, Your Honor, the state obviously would object to any kind of bond reduction. The defendant has 4 prior felony convictions, so he is a habitual offender. And at least 2 of those are in sequence. Also, the nature of this crime, it's alleged that both the defendant and Jamal McCain, another the co-defendant, gunned down the victim in this case, and it is on video. You can see 2 individuals gunning an unarmed victim down and shooting him multiple times. Both of the individuals doing that.
Anything you want to add, sir? You need to go? Okay. All right. A couple of decisions the court's going to make. Number one, this court is going to deny the motion for bond reduction. I've reviewed your criminal history. I have reviewed the circumstances of the offense. Those are the key determiners in determining what a bond is under law. Number one, murder. Yeah, that is the most aggravated and violent crime unless it's multiple murder. Number two, you, according to this indictment, have at least 4 prior felony convictions that dating back 24 years. And not the least of which is a conviction of robbery in 2007, which is a violent crime. The others are, it looks like, illegal possessions of controlled substances, which are felonies. So this, if true, constitutes a habitual offender. Your punishment range is no less than 25, no more than life years in prison. And that's as serious as it gets. So this is, number one, a serious felony of murder, a most serious felony. It's the use of a firearm. Somebody is killed. It's a violent crime. You have multiple felony convictions, including another violent crime. And in reviewing the probable cause affidavit, this court finds that $1 million in bond is most reasonable under the circumstances of the case and your rich criminal history. So we're going to set this for trial.
We ask that it be said as soon as possible.
All right, y'all, what do y'all need to do to get ready? Because I'm gonna try to accelerate this, please.
Your Honor, won't take much. I think the co-defendant is currently set for
Don't-
October. So
Anything can happen in a case.
I think we'd prefer to go on the co-defendant first in October. I think that's when we're set to go on that one. We've got everything ready. Mr. Marshall was arrested after this, after we received some
Right,
additional information.
Lacey, I need this set right after the co-defendant's case.
Yes, sir.
Okay, we'll get to, get it, please
Yeah,
note it.
got
And
the file real quick and then
All
I'll
right.
get them a date.
anything else on this?
No, Your Honor, we'll be
Thank
excused
you.
to that.
That is
meeting.
all. Yes.
Maybe look at it again if we're not.
Yes, sir. Santos Navarez.
Yes, Your Honor. Santos?
Defendant here is charged with a burglary of a habitation, a 2nd-degree felony here. And this one's old.
It is. The state, if I may address the court, the state. and I
Who's on this
have
one?
talked,
The state?
Mr. Boyd.
Birmingham.
No, it's Mr. Boyd.
Hold on, he's pulling it. There's that case. I mean, these are the hybrid files which we don't accept. Hybrid representation documents.
The state and I have been talking to settle this, Judge.
Yeah, how's that going?
They're fairly well.
What are we gonna do?
I need 2 weeks. The question is restitution.
You got it in 2 weeks?
Yeah, there's co-defendants, and so we're discussing restitution. There is an offer that probably we're going to accept.
All right, just reset 2 weeks, okay? Thank you.
So
24 CR 1711 is now called the State of Texas versus Kevin Wayne Turner. Mr. Turner is present with Mr. Rennick, his attorney, and the state's attorney.
Sorry, Judge.
That's okay. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, you.
I don't have it in my queue. Is it on another date? Was it on another date?
No, sir.
Judge, he needs to come in front of me and share a fingerprint. I'm sorry. It was in my queue.
Yeah, he was reset. He was being reset. That's Tom, Burbank. Can you help him? Is that yours?
yeah,
Oh, that's what we get to reset it.
oh, I took it on you.
Thank you.
Sorry, I was confused.
You never have to come back.
Like I gave it to you.
That's the way Tom makes it.
July 10th.
Confuses a lot.
Way to go.
Mr. Ashworth.
Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Your Honor.
And you are Kevin Wayne Turner.
Yes.
In summary, sir, this indictment in 24 CR 1711 states that on or about June 13th, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with here, sir? If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. There is no fine. You do well, we can shorten it to 1/3. 3 1/3. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal. Do you understand? How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty? Here, help me out. If you can pass that to him. Did you sign that document, State's Exhibit 1?
Yes, sir.
Did you understand it? Discuss it with Mr. Rennan? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea if freely and voluntarily made. Hold on, everybody. I can't hear. Everybody, thank you. You were mentally competent to enter your guilty plea. There is enough evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with representation provided by your lawyer. All true, so help you God.
Sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
Yes, please, Judge.
Okay, let me ask you a couple of things. Criminal history on the defendant?
No, sir, I don't
No,
think there is.
This is an agreement for 10 years. Is, you're asking for less?
Yes, Your Honor, I am.
What state saying?
I don't have a problem with that, Judge,
What
just
we
based on
thinking?
the
I would
history.
ask for 3, Judge.
How about 5?
5, if the judge
Because again, once again, it can be, it's a third. You can shorten it to a third with,
would
and
be,
gotta be longer than a misdemeanor,
I understand.
which
that
is
5
2 years.
If the court were considered 5, that would be very
Okay.
acceptable to us.
All right. If nothing further, I'm going to find, sir, you have pleaded guilty voluntarily.
Yes.
You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea for State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any findings so long as you follow the terms and conditions of probation, which will be for 5 years in length. The probation officer will go over these with you. These are normal and customary. Essentially, most of these, if not all of them, are conditions I have to follow every day.
Yes.
There is no fine here. There is, though, you're going to be ordered to take and pass defensive driving course as a condition of probation. And people kind of laugh about that one. But the two things, number one, it helps you kind of remember in your mind that this is a 4,000-pound missile you're driving around, and it can do a lot of tissue damage if it hits something else or people. So we got to be very careful in the way we operate motor vehicles on public places. Plus, you're going to get a reduction in your insurance by doing this. So, so it's a win for a probationer. Here, please, meet with the probation office and you will
Okay.
begin now. Thank you.
Okay, thank you, Judge.
All right, we now call 23 CR 1490, the state of Texas versus Joshua Booker, who is present with his attorney, Mr. Wilkerson, and the state's attorney. Does the defendant waive a formal reading of this indictment here? Can we proceed in summary?
He does, Your Honor.
All right. In summary, Mr. Booker, this indictment alleges in paragraph 1 that on or about December 1st, 2021, in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child. Do you understand what you were charged with here?
Yes.
Okay. Because the child was younger than 14 years of age, this becomes it's referred to as a super aggravated first-degree felony, which means the punishment range is enhanced from not less than 5 to not less than 15 years imprisonment, up to 99 years imprisonment or life imprisonment. Do you understand the punishment range applicable? And I guess as well, a fine up to $10,000 could be assessed, but that's not going to be of consequence in this case, correct?
That's correct.
You understand what you're facing here, sir? Yes, the gaps are yes. That's nice, lady. Can hear you. The agreement's been reached where you would be pleading guilty, sentenced to 45 years imprisonment. Is that your understanding of the agreement?
Yes.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty, sir? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tendered into evidence without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God. Is that true? Yes. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived?
Yes, Your Honor.
Sir, I'm going to follow this agreement. If nothing further, I'm going to find you, Joshua Booker, are pleading guilty to this aggravated sexual assault of a child as indicted in 23 CR 1490. You were doing this voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 45 years. Do you understand what has happened today, sir? And you'll be given credit for all time that you have served in connection with this offense up to now. Anything else?
And Your Honor, just after the victim would like to give an allocution.
Okay.
And one more thing from the defense, Your Honor.
Yes, sir, go
During
ahead.
the pendency of this case, Mr. Booker's ability to communicate with the outside world was restricted due to some statements that were made to a Paige Davis, who is not one of the is not the victim or the victim's mother or anything of that nature. In this case, we'd ask that those restrictions be lifted. Ms. Davis is here to provide some testimony if the court would like to hear it.
Okay. You're asking me to,
Allow him to communicate.
it's up, I think that's up to the jail.
Well, this is.
No, he said I made a ruling. I made a ruling on this earlier.
That's correct, Your
I'm gonna
Honor. I
have to
believe you.
review it, but
Yes, sir.
is there any
There's
objection to
no,
what
there's no
he said?
objection, Your Honor.
Okay. I don't have a problem with allowing that, and we'll get that information over to the jail. You just obviously have to be careful what you say in all conversations. Can't be threatening, and it can't be vulgar. And all right. Anything else on this?
Just the allocution.
All right, we're going to go dark here because this involves a child, and we'll be back shortly.
Judge, if you just mute him,
I'll mute.
yeah, we won't have to stop the live stream.
All right.
Yeah.
Stand by. Thank you. Giles,
Yes, sir.
get ready. Melissa Bell.
Yes, she's present. I need to speak with DA Borden real quick. I think we'll get this resolved today. If you give me 1 second.
Yes, sir.
All right.
Let me go to, there's a Jameisha Butler with Darian Constant is the attorney. I'm not familiar with Mr. Constant. See you around? Is Jameisha Butler here?
That's reset.
Nobody's told me.
Sorry.
2 cases, looks like.
Yeah, I'm not sure if the files were full or not.
And can somebody call David Grove? He was supposed to be here an hour.
Called him in here earlier.
Hey, wife, Caleb Landry. Caleb Landry, please, Mr. Landry.
Offers a year straight.
Okay.
Hey, Mike, will you, I don't stand by that. Really, put it back on. If you don't mind, thank you.